Sir, we are live and I think we can start with the session with your permission.
Yeah, kindly go ahead.
Okay, sir. Thank you, sir. Asmita, over to you.
Yes, ma'am. A very pleasant evening to all intellectuals, honorable guests, and my respected teachers. On behalf of Keli Society's Keli College of Law, Navi Mumbai, I, Asmita Sani, extend a very warm welcome to you all on our last webinar of the 9th National Webinar Series 2020. I shall be the host for today's session along with Dr. Amrita Singh ma'am, who will be moderating the event. Our guest speaker of the session, Professor Ashutosh Tripathi sir, has joined us. We welcome you, sir. Today, sir will be enlightening us on the topic, the Nexus, Governor, Speaker, and Anti-Defection Law. With wholeheartedness, I express my sincere gratitude to the members of Keli Management for their blessings. Dr. Prabhakar Kore sir, Chairman of Keli Society, Mr. Mahantesh Kawat sir, Governing Body Chairman of Keli College of Law, Member of Legislative Council and Chief Whip of Government of Karnataka. Dr. Mallikarjunia sir, Principal of Keli Society's Keli College of Law, Bangalore, and the Director of Keli Law Academy, Bangalore. And a very big token of appreciation to our Principal sir, Professor Dinkar Gitte sir, for his constant support and guidance. I now request Dr. Amrita Singh ma'am to kindly take over and continue with the session. Over to you, ma'am.
Thank you so much, Asmita. Thank you very much. And again, a very warm welcome, sir, for accepting our invitation and joining us to deliver a lecture on a very pertinent topic. And before I give this session to you, sir, I just would like to take this opportunity to introduce your good self to our audience. Sir has done BCom LLB from University of Allahabad. Sir has done LLM from NLSIU Bangalore. And sir has presented various papers in international seminars like World Congress on International Law. Sir has also published paper on the topics related to international law and constitutional law in journals like International Journal of Consumer Law, NLSIU Bangalore. Sir, with so much of experience and learnings, I think we all are very much fortunate today that we will be witnessing a wonderful lecture today. The session is over to you, sir.
Thanks a lot, ma'am. So first of all, I will like to thank Professor Dinke, the principal of Keli College, for inviting me, along with Dr. Amrita Singh, for inviting me to this wonderful gathering of people. So before I start, I want to give certain premise about my whole lecture because time is less. So, and the topic is very, very relevant. So in the previous days, we have seen that the use of anti-defection law or the misuse of anti-defection law in the case of Madhya Pradesh, or in the case of, say, before that, there was something in Karnataka. Thereafter, we have seen something similar to that in Rajasthan and all those places. This is a very, very relevant topic. So what I will tell you is a little bit brief about the anti-defection law in the Indian Constitution, little bit about the Speaker of the Assembly, and then we will see a little bit about the governor, and with the time permits, then we can see about something related to the how they are interconnected. So first of all, little bit about the anti-defection law. So especially in our part, especially in northern part of India, there's a very famous saying, Aya Ram Gaya Ram, which is used in politics. So Aya Ram Gaya Ram, basically it is based on a person whose name was Gaya Ram. He was an MLA in the Legislative Assembly of Haryana. So in 1967, on a particular day, he changed his party thrice, which means on a single day, he changed his party thrice. So from one party, he went to the other party, and from that other party went to the other party. So basically, he was responsible for this famous name, Aya Ram Gaya Ram. So this brought to the notice of our lawmakers that this is very, very serious thing, because do remember, in India, still when we vote, we generally vote for the party, because of the simple reason that many of us, when we go vote and we vote, we generally don't see the name of the candidate. We generally see the name of the party, even not the name. Generally, we recognize the party through their symbol. And if after seeing the symbol, we vote, and thereafter the person changes the party, then technically it is a cheating with the mandate of the people. Because of a simple reason that why people have voted you. People have voted you because maybe they believe that you belong to a party in which they are having a liking. So if a person belongs to the Congress and the people are voting for the Congress, it means that people have belief in the policies of the Congress or in the BJP, vice versa. So after that, what happened before this whole thing happened, there was some debate going on that we have to do something. So this brought 33rd Amendment to the Indian Constitution. The 33rd Amendment to the Indian Constitution was there, and 33rd Amendment to the Constitution was brought in the year 1974. And before this 33rd Amendment, what used to the process is that if any MLA wants to resign, so he just have to write a letter to the speaker, and the speaker is just like a letter box. So there is no role of the speaker in the resignation of the MLA. So MLA used to write a letter submitting his resignation. So the moment he writes the letter, he is free. There is nothing called as acceptance of the letter. So the moment he is writing a letter, it is presumed that he is resigned from that particular party. After the 33rd Amendment, what happened is that they brought certain changes in Article 101 and Article 190. And now the rule is that if a MLA or MP wants to resign from his post, then they have to submit a resignation letter, and the resignation letter will be going to the Speaker of the House. The Speaker will then, by all possible means, the Speaker will try to find out whether the resignation is voluntary or not. So for that purpose, the Speaker will meet the people who have resigned, and after that, the Speaker will accept the resignation. Which means after this 33rd Amendment, the role of the Speaker is very, very relevant in the case of the resignation of the MLAs, because till the time your resignation is not accepted by the Speaker, you are still a MLA. So that is a significant change which happened after the 33rd Amendment. So do remember, before 33rd Amendment, if any MLA and MP wants to resign, he just have to submit his resignation. There is nothing called as acceptance by the Speaker. After the 33rd Amendment, now the law is that it should be accepted by the Speaker. Then only it will be formally accepted. Later on, we realized that this is also not going to be enough. So finally, around 1985, we added 10th schedule to the Indian Constitution. By the 52nd Amendment, we added 10th schedule to the Indian Constitution. That is called as a Anti-Defection Law, which we all know. So what is Anti-Defection Law? Anti-Defection Law say that if any person after winning from a particular party joins another party, then that is a ground for his disqualification, which means it is one of the disqualification. If you win from a particular party and joins another party, that is a coming under the Anti-Defection Law. Anti-Defection Law originally was having two exceptions. One was 1/3 defection. So 1/3 defection means that 1/3 MLAs can defect from a party and they can join or make a new party. So that was one exception. So if 1/3 MLAs or MP are defecting, then Anti-Defection Law will not be applicable. Second exception was the 2/3 of MPs or MLA, if they merge into some other party, that was also accepted. So there were two exceptions to the Anti-Defection Law, 1/3 defection and 2/3 merger. But later on, in 2000, the Parliament again amended the 10th schedule, and now the 1/3 defection part is removed and only this 2/3 merger part is allowed. So I repeat, now there is only one exception to the Anti-Defection Law, is that if more than 2/3 MLAs or MP are leaving the party, then it is allowed. So if you remember, after the Lok Sabha election, what happened in Rajya Sabha, that all the MPs belonging to the TDP, Telugu Desam Party of the Rajya Sabha, So I think there were 4 or 6 in the Raj Sabha. So after the 2019 election, all these people have joined the BJP. So on them, the anti-defection law will not be applicable. Same thing happened in the case of Rajasthan Assembly. So in Rajasthan Assembly, there were 6 MLAs who won the election on the ticket of the Bahujan Samaj Party. But after winning the election, they joined the Congress. So it was not coming under the anti-defection law because more than 2/3 people are joining the party. So that is right now one exception to the anti-defection law. I hope till now it is clear. So I told you 2 things mainly about the anti-defection law, the 2 significant changes which happened. The first change happened with the 33rd Amendment to the Indian Constitution, which now say that till the time Speaker is not accepting your resignation, then your resignation is not completed. Second is the anti-defection law, which added the 10th schedule. And now it say that any person, if he joins another party, then his membership is over, with one exception, that is the 2/3. Earlier there was one more, 1/3, but now it have been removed. Now comes the critical role of the Speaker of the House. So Speaker of the House plays a very, very important role in both the cases. The Speaker of the House plays a very, very important role in both the cases. Once the MLA is resigning, and second also in the case of anti-defection law. So if we all remember, in the case of recent controversy in the case of Madhya Pradesh, where close to say 20 MLAs who won the ticket from the Congress, later on they want to resign. So they submitted the resignation, but the Speaker was not accepting. Same way, it happened in the case of Karnataka also. Why? Because the Constitution of India does not provide any time limit. So still there is no time limit mentioned that in what time, what is the maximum time in which the Speaker have to take a decision of accepting the resignation. So generally what happens, even though we know that Speaker should be not biased, he should be a neutral person, but Speaker of the House will always belong to the ruling party. So be it the parliament or be it the state assemblies, you will find the Speaker of the House will always be belonging to the ruling party. So generally what happens in such cases, the Speaker of the House will play with the ruling party. So in the case of Madhya Pradesh, we all have seen that the Speaker was not accepting resignation and it was pending for a very, very long period of time. Same thing happened in the state of Karnataka. So here comes the role of the Speaker in the in the case of the resignation. Same way what happens in the case of anti-defection law, the Constitution provides that who will decide, so which authority will decide whether there is an anti-defection happened or not. So who is the ultimate authority to talk about where there is a defection or not? So 10th schedule provides that Speaker of the House will be the authority to decide about the defection cases. So Speaker of the House will act in a quasi-judicial manner and he will take the decision that whether there is an anti-defection law will be applicable or not. Now, again, what happens? There is no time limit mentioned in the 10th schedule. So there is no time limit mentioned in the 10th schedule that what is the maximum time in which the Speaker have to take this decision about the anti-defection law. So suppose what will happen? Suppose 3 MPs of a party joins the other party, then that party will go to the Speaker and will tell the Speaker that kindly apply the anti-defection law on these 3 MLAs because they won the election on our ticket, but right now they are joining the other party. Now the Speaker have to take the decision. Originally, the anti-defection law provides that the decision of the Speaker shall be final and it is beyond judicial review, which means whatever decision is taken by the Speaker of the House, that is final, which means no action can be taken on the decision, which means that is the final decision, whatever decision the Speaker of the House is taking. You cannot challenge. But there's a very famous case, Ki Hoto Holan versus Jachilu. Ki Hoto Holan versus Jachilu. So that is a very, very famous case related to the anti-defection law. So in that case, the Supreme Court held this portion of anti-defection law as unconstitutional by applying the doctrine of severability. This portion means that portion of anti-defection law which is saying that the decision of the speaker shall be final. So Supreme Court is saying that this particular provision of the Indian Constitution of the anti-defection law is against the judicial review. And judicial review is a part of the basic structure of the Indian Constitution. So as we all know that judicial review is a part of the basic structure of the Indian Constitution, which means even by the process of the amendment and all those things, you cannot take away the judicial review power of the High Court and the Supreme Court. The Supreme Court struck down this provision of the anti-defection law, which makes the decision of the speaker under the anti-defection law final. So right now, the law is that the decision of the speaker is subject to challenge. So you can challenge whatever decision is taken by the speaker in the High Court or in the Supreme Court, because judicial review is a part of the basic structure and no one can take away. But at the same time, the big problem is that still in the Indian Constitution, there is no time limit mentioned that under what time the speaker should take the decision. So what used to happen, the speaker will keep on pending this decision. The speaker will keep on pending the decision if it is benefiting his party. The speaker will keep on pending the decision if it is favoring his party. If the anti-defection law is happening in some other opposition party, then generally you will see that speaker is taking very quick decision, because the speaker is not required to follow any time limit. So this is a very, very controversial thing. So recently what happened in the Manipur, so there is a very famous, I'm giving you the name of the case. It is Kesham Meghchand versus Honorable Speaker of the Manipur. So in this case, what happened? We all know, once the election of the Manipur was declared, the result was declared. So BJP made the government, and certain people who won the election from the Congress, they joined the BJP. And now the Congress went to the speaker for the anti-defection law, saying that these people have jumped the party, so they should be removed. Now what happens? The speaker is not taking any decision because there is no time limit mentioned. So the Congress party went to the High Court, and from there the case is coming to the Supreme Court. The Supreme Court recently in 2019, I think 2020, the Supreme Court is saying that if the Constitution is not giving any time limit, it doesn't mean that the speaker can take time as per his wish. The Supreme Court in this case is saying that except in certain exceptional cases, the speaker should take decision within 3 months. So Supreme Court is saying that except in certain exceptional cases, the speaker should take the decision within 3 months. So some guideline is coming from the Supreme Court that the speaker should be taking the decision within 3 months. Why the Supreme Court is saying so? Because what happens? Otherwise, the whole purpose of the anti-defection law will be defeated. Because suppose the member jumps the party after the result, and speaker is taking the decision after 4 years. So the whole purpose of the anti-defection law is going to be defeated. So what was the object, why it was enacted? That is going to be defeated. So in this case, the Supreme Court is saying that from now onwards, the speaker should take the decision within 3 months, unless until there are certain exceptional cases. So now the Supreme Court have stepped in, and they are saying that in the anti-defection law cases, the speaker should take the decision within 3 months. Not only that, the Supreme Court also suggested to the government, that it will be better that if this power to decide about the anti-defection law is taken from the speaker, and it should be going to some impartial tribunal headed by the retired judge of the Supreme Court or someone else. So Supreme Court is saying that we should take this power from the speaker and we should give it this power to some other authority. But that is only an observation of the Supreme Court. It is not binding. The Supreme Court is only giving an observation that this is what they think and this is what will be better if the parliament thinks so. Because we all know that there's a controversy around the role and position of the speaker in realm to the anti-defection law. But one thing is very clear, Supreme Court have stepped in and said that the speaker should take decision within 3 months. And second thing which the Supreme Court is suggesting, it is only a observation that the parliament can make certain law and take this power from the speaker and give it to the some other impartial authority. So under anti-defection law, I hope now you must be clear that the speaker plays a very, very critical role. The speaker plays a very, very critical role because of the simple reason that it is the speaker who will take the decision in both the cases, whether to accept the resignation or second thing is when to take this decision in the anti-defection law. Now what happens, some people say right now that anti-defection law is also not serving its purpose. Why? Because take the case of Madhya Pradesh. So we all know what happened. There are 230 seats. So Congress won around say 115, BJP got 107. So it was a close contest between BJP and Congress. Congress formed the government in 2018, December. Now what happened afterwards? Some people resigned from the Congress. Now what happens if the 20 people are resigning from the Congress? So what will happen? What will be its impact? So the impact is now the total membership of the House will be say 210 because 20 people have resigned. And now the majority will be taken out from 210. So which means the majority will be 106. Is it clear? So the question is that now what will happen is that the majority is coming down. Why? Because certain people have resigned. So majority is coming down. So if the majority comes down, then the BJP is having the majority. So they will say that we have the majority, we will form the government. So if you recall, this is what exactly happened in the case of Madhya Pradesh. Same thing happened in the case of Karnataka few months back. So same thing was there in the state of Karnataka also. So some people is saying that still we have to do a lot of things in the case of anti-defection law. Is it clear? Okay, now we will see the role of the speaker. Again, why I'm emphasizing on the role of the speaker is that the speaker is generally playing the delaying tactics. So if the speaker is not accepting the resignation, whether the governor can step in, and take this thing to a logical conclusion, or whether those people who resignations are not accepted, whether they can go to the Supreme Court of India or the High Court challenging that particular decision. So some people say that the whole conflict between this speaker and the anti-defection law will not be there if the role of the speaker is performed in a constitutional and efficient manner. So before I tell this, there's something about the governor. So we all know that in India, we are following this system of the government in which technically the chief minister and the prime minister along with his cabinet are the real executive head. But we have president and the governor as the head of the state and head of the respective state government. So under the Indian constitutional scheme, the role of the governor is very, very similar to the role of the president. But there are two major differences. First difference is that president is elected. The president is elected by the electoral college consisting of the members of the Lok Sabha, Rajya Sabha and the member of legislative assembly. So they vote in the case of the president election. Same way, president can only be impeached. So once a person is appointed as the president, then only he can be impeached. He cannot be removed without the process of the impeachment. And we all have seen that the process is such a stringent process that till now no president have been impeached. Till now no president have been impeached because the requirement is 2/3 of total membership. So if you want to impeach the president, then you need to have 2/3 of the support of both the Lok Sabha and the Raj Sabha. Whereas if we see, the governor is appointed. The governor is appointed and the governor holds the office till the pleasure of the president. So governor is not having the security of the tenure. Unlike the president of India, the governor is not having the security of the tenure. So this is the reason why you keep on seeing that many times the governor will be removed, especially the governor will be removed once there is a change in the government at the central level. So the moment you will see that there is no new government coming at the central level, you will find that existing governor will be removed. So they will be asked to resign because the constitution says that the governor will hold the position till the pleasure of the president. Till the pleasure of the president again means till the, so here again pleasure of the president is generally, because we all know there is Article 74 of the Indian Constitution which say that president shall act on the advice of the cabinet. So it's not the pleasure of the president, it's technically the pleasure of the Council of Ministers. So this is the reason why the governor post is not as secure in terms of his tenure, in terms of his appointment, because they are appointed by the government and they can be removed by the government at any point of time. Apart from that, we will see that governor is having the same power as the president. But if we come to the question, who is having more discretionary power? So who is having more discretionary power, whether the president or the governor? So is there any situation where the president or the governor can act on his own, or they will always act on the advice of the cabinet? So we all know the crucial role of governor in the case of Article 356, because it is a governor generally who will recommend that there should be a president rule in any particular state. And again, the governor is generally belonging to the ruling party. We all say that governor should be impartial, he should not be involved in the party politics and all those things. But we will always see that in all those states where opposition is having the government, there will be some problem with the governor of that state. So especially in the bigger states. So as you are from Maharashtra, so for example, right now, some problem is going on between the chief minister and the governor. Same thing happened in the state of West Bengal. But the important thing with the governor is that when we were drafting our constitution, so this question arose that how we should elect the governor. So the Constituent Assembly debate will give you the answer that there is a proper debate and discussion that how we should elect the governor. So there was one proposal that governor should be elected directly by the people. So just like people vote, so the people will be voting for the post of the governor. But the opposition to this particular claim was that if the governor is also directly elected by the people, and we all know that the chief minister is technically directly elected by the people, then there will be a clash between them. Why there will be clash between them? Because governor will also say that I am also coming directly elected by the people, so I have also legitimate authority to govern. I have also legitimate authority to govern, so I will not act as a mere rubber stamp because I am elected by the people. So I will be having some power. So this proposal was rejected on the ground that it can create a big conflict between the chief minister and the governor. Second proposal was that just like the president is elected by the member of Lok Sabha and respective state assembly, why can't we have the same proposal for electing the governor? So in the case of the governor, only the member of legislative assembly should be voting. So MLAs of a particular state should vote to elect the governor. But again, all these proposals were dropped out because of the simple reason that it will create a burden on the exchequer also, because conducting election will need money. And second thing, that it can delay the whole process. It can delay the whole process. And at the end of the day, every people wanted that governors should act as a link between the central government and the state government. So if the governor is elected by the member of legislative assembly, then what will happen? He will always act in the favor of that particular state. So he will not be acting in a impartial manner. For example, chief minister is much more concerned about their respective state as compared to the whole India, because their interest lies in their respective state. So governor should be such person who will see these things from an impartial view. So if something is going on which is problematic, he should be informing the central government. Because do remember why the role of the governor is very, very critical, because although we say that we are a nation, but technically if we go into the detail, India is not having any of the characteristics of a traditional nation forming. So we are, for example, generally nation is formed on the basis of what? Either on the basis of the religion, or on the basis of the language, on the basis of the culture. Like, so there must be something which is uniform throughout the nation, which will bind each and every one of us. That is all over world. So generally nation is formed on that particular premise. And we all seen that when we were drafting the constitution, at the same time the partition happened. So we see that the state government is not that much sufficient, that much capable of dealing with all these things. So partition of India have played a very, very important role in making state much more powerful as compared to any other states in the world. So in India, as we all know, that Indian constitution is much more biased towards the union, because union is the entity which will try to bind us all together. Because as I told you, there's nothing common between us. I think except the national flag and national anthem, nothing is uniform throughout the nation, because our language is different, our culture is different, our food is different, our way of life is completely different. So what is the culture in Maharashtra? It is completely different what is there in Uttarakhand. So this is the reason why the constitution maker was very, very concerned about the role of the governor. So they wanted that the governor should be such a person that who should see the things in an impartial manner. So who should see the thing in an impartial manner, and if the state is not going as per the direction of the constitutional framework, then he should report to the central government, and then the central government should take certain appropriate action. That is what we see Article 356. So this is the reason why we have Article 356 of the Indian Constitution, because sometimes it is necessary to go for this law and order situation. And now if I come to the difference between the discretionary power of the president and the governor. So if you read Article 163, and if you compare it with Article 74, so Article 74 is there for the president and Article 163 is there for the governor. So Article 74 say that there shall be a council of ministers and president shall act on the aid and advice of the council of ministers. And of course, the president of India can say no only once. So if the president is not happy with any advice or anything, so he can send it back only once. But if you see Article 163, you will find that there is a difference. What is the difference? The difference is that it is saying that governor shall act on the advice of the council of ministers, but at the same time, there will be certain things in which he will be having his discretion. So I will ask you, all of you, to kindly read Article 163. So I am reading. It is saying there shall be a council of ministers with the chief minister at the head to aid and advise the governor. So till here, it is very, very similar to Article 74. So if you compare 163 with 74, it is similar. But here comes the change. In the exercise of his function, except, that is very important line, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion. if you read clause 2, it is much more establishing the fact that governor is having more discretion. So if you read article 163 clause 2, it is saying if any question arises, so if the question is arising whether any matter in which the governor is having a discretion or not, who will decide? The governor will decide. So governor will decide whether he is having a discretion in any matter or not. So there are two types of things. So if you read, there are certain matters in which the governor will exercise the discretion that is mentioned in the constitution. That is article 200 and 201. So if you read article 200 and 201, so there are certain matters in which the governor will reserve the bill for reconsideration with the president. So if the assembly is passing the bill, the governor will not sign it, the governor will send it to the president. So there are certain matters which are mentioned. So in these matters, the governor will having a proper say. Other important thing is that if the governor thinks that he need to exercise his discretion in some other manner, then he have this power. So in that respect, the governor is having much more discretionary power as compared to the President of India. I hope it is clear that what I'm trying to establish, the fact is that governor in functioning of the state is having much more power as compared to the President of India, because President of India will always act on the advice of the Council of Ministers. So if we read Article 74, you will not find the term discretion anywhere in relation to the president. So you will not find any place where the president will act on the discretion as mentioned in the constitution. Of course, through case laws, it is established that president can act on his discretion in certain cases. So for example, if the Prime Minister of India is, along with his Council of Ministers, is saying to the president right now, say, to dissolve the Lok Sabha. So president can say that, wait, I will not be dissolving. I will try to ask if any other party is willing to form the government or not. So in such cases, the president can exercise his discretion little bit. But governor is having much more discretionary power. So if I come to the realm of the conflict or interchanging role between the speaker, governor. So if I will take you back to the Madhya Pradesh Assembly. So what happened in Madhya Pradesh Assembly, that it is just before the corona. When the people have resigned, the speaker have adjourned the house sine die. Citing that there's a corona and all those things. Now what happens in the meantime, the people have resigned, and now the BJP is saying that there should be a no confidence motion. This government have come into minority, so this government should go and prove the majority. So this government should be proving the majority. Now what happens? Who decides when the house will come into session? The only constitutional requirement is that there should not be a gap of more than 6 months between the two sessions of the parliament or between the two sessions of the legislative assembly. So this is the reason why we have seen recently most of the state assembly was assembled even for a single day, because the constitution say that there cannot be a gap of more than 6 months between the two sessions of the assembly. But when the assembly will be sitting, for how long it will be sitting, who decides? Same with the parliament. Who decides when the parliament is going to meet, for how long it will be meeting, what is the duration? So it is again the decision of the governor. But again, governor will act on the advice of the Council of Ministers. So governor will ask for the assembling of any assembly only when the chief minister and his Council of Ministers is saying that these are the dates and these are the matters which are going to be discussed. So kindly convene the session of the assembly. So now what happened in the case of the Madhya Pradesh, that the chief minister is not asking the governor to convene the assembly. And the reason is very, very obvious, because he knows very well that he is in minority. Now the question is, can the governor on his own convene assembly session? Whether the governor on his own can convene a assembly session. Because the chief minister is and his council of ministers is saying that because of corona and all those things, it is not safe to convene the assembly, and they are not willing to convene the assembly. But governor is getting this report from various quarters that this government is a minority because 20 people have resigned. But the chief minister is saying that these 20 people haven't resigned because now what happens, their resignation is not accepted. So still their resignation is pending before the speaker. So we cannot say that they have resigned, because till the time the speaker is not accepting the resignation, their resignation is not final. So this matter is going to the Supreme Court of India. And in this case, the Supreme Court of India is saying that the constitution itself is giving discretionary power to the president, to the governor. So constitution itself is saying that if the governor thinks that this is the matter in which I should exercise my discretion, then he can exercise. And if the governor thinks that this government is in the minority right now, then the governor is having all the power to call for the assembly session. The governor is having all the power to call for the assembly session, even though the council of ministers is not saying so. So in this particular thing, when the governor thinks that there is a government which is in minority, the governor can act on his own without going with the aid and advice of the council of ministers. Same way, the Supreme Court also directed the Speaker of the House of Madhya Pradesh that kindly take the decision in a very fast manner. So kindly take the decision. And even though you are not taking the decision on the resignation of the people, still it cannot be a ground for not calling the assembly. Because if the people, it is not necessary that each and every people will come for the voting. It is not necessary that each and every people will coming for the voting. So if the people have resigned and you think they haven't resigned, then they should come and vote for you in your favor. If they have resigned, then of course they will not be coming. So Supreme Court is saying that just because certain resignation is pending with the speaker, it cannot be a ground that the assembly should not be convened. And finally, we all have seen that the Supreme Court ordered and then the assembly was convened. And before the majority can be proved in the House, the then Chief Minister Kamal Nath resigned. And right now we are seeing that on all those people, and later on the speaker have accepted all the resignation and all the thing. And right now we are seeing that the election is happening, the by-election is happening in all those seats. So in such a thing, you are seeing that there can be a conflict between the speaker and the governor. I hope it is clear to everyone. Okay, so last 5 minutes, I will devote to another controversial power of the governor, that is the governor power in realm to the federalism, that is the misuse of Article 356. So some people say that Article 356 is most misused article of the Indian Constitution. Just like some people say that Article 124 subclause 3, which say that a person who is a jurist can also be appointed as a chief justice, can also be appointed as a judge in the Supreme Court of India. So that particular article have never been used. So we have seen that till now, not a single jurist have been appointed as a judge in the Supreme Court of India. So many people think rightly that this is one of the article which is never used in the Indian Constitution. Same way, many people, and they are perfectly right, that the people think that Article 356, that is one of the most misused article of the Indian Constitution. And the journey started just after the Constitution came into force. So after the Constitution came into force, there was an election happened in, say, in then southern part. 1959, President rule was imposed in Kerala. Why? Because in Kerala, for the first time, there was a communist government formed, and there was a difference with the central government, and there was a imposing of the president rule. Because president rule, what it is, generally we see that there are three types of emergency: national emergency, state emergency and financial emergency. But if you read Article 356, do we find the term emergency there? So if you read Article 356 in the Indian Constitution, do you find the term emergency? So you will not find the term emergency there in Article 356. Why there is a duty related to the precedent rule? Because there's one more important article which is just given before 356, that is Article 355. So it says that duty of the union to protect states against external aggression and internal disturbances. So you cannot understand the relevancy of Article 356 without understanding the importance of Article 355. We all know that law and order is a state subject matter and every state have a police. But at the same time, no state in India have their own army. So a state is not having armed forces. So armed forces is Indian Army, Indian Air Force, and Indian Navy. So if there is any external aggression, then it is the responsibility of the union to protect them. It's the responsibility of the union to protect all those states, because maybe the state is under near to the border state and all those things. So it is a response. So their police machinery will not be sufficient to tackle such type of cases. So in that cases, the state is not following the directions of the union government, then they can be imposing of the precedent rule. So for example, if you read Article 365 in the Indian Constitution, it says that effect of failure to comply with or to give effect to directions given by the union. So if any state is not following the directions which are given by the union government, then it can be a perfect ground of imposing the precedent rule. So suppose India is having a war with a country and the central government is giving certain directions to all the state government, then it is a duty of all the state government to comply with those directions. The state is not direct following it, then there is a chance that it's a perfect ground of imposing the precedent rule. So if you impose the precedent rule on such ground, then it is not much more controversial. For example, suppose the parliament is passing a law, just like take the case of the CA, Citizenship Amendment Act, or take the case of the recent Farms Act. So the law is passed by the parliament with proper process and procedure. Now, if the state is not happy with any of the law, so many states are not happy with the CA, many states are not happy with the, say, Farms Act, so they cannot say that they will not implement. If they are not happy with the law, then there is only one option, that they can go and challenge the law in the Supreme Court on the ground that it is violating the federalism or any other ground of the constitution. But constitutionally, you cannot say no to any of the law which is passed by the parliament, because every law which is passed by the parliament, that is presumed to be constitutional. And if you're not happy with the law, so if you're saying that we will not implement the CA, then that is a ground of imposing Article 356. So if you're not happy with the CA, you have all right to go and challenge the law under Article 131 of the Indian Constitution, or filing SLP and all those things. But you cannot say no to any law which is passed by the center, the parliament. But the problem with Article 356 is that many times it is imposed merely on political grounds. Many times it is being imposed merely on the political grounds. So governor will send a report saying that this state is not working as per the constitutional framework. Because if you read Article 356, it is nowhere mentioned that what are the specific grounds on which the precedent rule can be imposed. It is only written, state cannot be carried on in accordance with the provisions of the Constitution. So if the state is not carrying out its functions in accordance with the Constitution, that can be a ground of imposing the precedent rule. But this term, not carrying out its function in accordance with the Constitution, it's a very, very subjective term. This is the reason why it is grossly misused. It is grossly misused. So for example, in 2016 in Uttarakhand, because I was here then also, so in Uttarakhand, there was a chief minister, Harish Singh Rawat, so he belongs to the Congress party, and the Congress was having government. So certain people have left the Congress, and later on what happens, the governor have recommended the president rule. The governor sent a report that this government is not functioning in accordance with the constitution, so there should be imposing of the president rule. So it was challenged by the Congress party, because Article 356 used to say that on what grounds you are imposing the president rule. So what is the report which is sent by the governor to the, what is the advice it is being given by the governor to the president? It is not subject to judicial review. But Supreme Court in the SR Bommai case, and later on in many of the cases, the Supreme Court is saying that we will not go into the detail of the advice, but we will see the documents. We want to see the documents. On that basis, you are recommending the president rule. So in this case of Uttarakhand, it happened for the first time in India. It happened for the first time in India that the Supreme Court is not saying only that you have imposed the president rule wrongfully. Supreme Court also reinstated the previous government. The Supreme Court is saying that Harish Rawat should be the chief minister and he should get a chance to prove his majority. So that happened for the first time in India, that a chief minister was reinstated by the Supreme Court, and the Supreme Court is saying that Article 356 in this particular case have been wrongly used. So now, after this SR Bommai case, we will see that if you make a chart, how many times the president rule is imposed before the SR Bommai case, which came around 1991, 1992, I think 1994, and after 1994. So you will find the numbers have been drastically reduced because of the certain guidelines which were given by the Supreme Court in the SR Bommai case. So one of the important guidelines is that whether the person is having, the government is having the majority or not, it should be decided on the floor of the house. So you cannot decide without giving a chance to the person to prove his or her majority. So the person, if you are saying that the person have lost the majority, then it should be proved in the house. Outside the assembly, who is supporting whom, that is not going to make any difference. The real picture will come when every person is getting a chance to prove the majority within the assembly. So as majority should be decided on the floor of the house. So this is all about my lecture. So precisely the emphasis on my lecture was that the speaker and the governor, sometimes they can create a constitutional deadlock position in India. So still there is not much clarity in the Indian constitution on the whole issue about this anti-defection law. So Supreme Court have rightfully stepped in recently and said that it is the duty of the speaker that they should take the decision under the anti-defection law within 3 months. But again, it is not relevant on the question of this particular in the term of resignation. So thank you all for your patient listening. So I am now open to the question. If any question you have, we can ask. You can ask.
Thank you so much, sir, for that wonderful and informative lecture. And I hope that our participants have benefited a lot today. Sir, with your permission, can we take up few questions?
Sure, ma'am.
Okay, sir. So the first question is by Dr. Pradeep Desai. He is asking, recently a trend is to shift MLAs to resort in other states and keep them for long periods. So for example, as it happened in the case of Madhya Pradesh while removing Kamal Nath government. So how you view this process? Is it a constitutional process or otherwise?
Okay, even the Supreme Court have said that technically have observed certain things, but at the same time, constitutionally there is no problem in it, because people can go from one place to the other and all those things. And the MLAs who have been locked into in any resort, they will never say that they have been locked and all those things. But ethically and morally, that is a very, very wrongful message going towards the society, that technically you are locking the people in one resort to the other so that they cannot talk, because they cannot mingle with the people and they can take their own decision. But till now, the constitutionally, the Supreme Court haven't given any ruling on that. And if it is constitutional, even though it is, we think and everyone think that it is unethical, but it is permissible. So till now it is permissible.
Okay, sir. Thank you so much, sir. So, two of our participants, Mr. Raju Manji and Mr. Chandrahasa, they are asking us a very similar kind of question. They are asking that governors and speakers, they have no more remained as constitutional institutions discharging non-partisan constitutional duties. Rather, they have become today the tools in the hands of ruling party to fulfill their political motives. What is your observation on that?
Okay, ma'am, the thing is that the role of governor is controversial since the beginning. So it is not like that this is coming into realm now. So this is controversial from the very, very beginning, and it started just after the constitution came into force. So as I gave you the example that in 1959, when the Kerala was imposed Article 356, it was not any constitutional crisis. It was not any constitutional crisis. It was justly purely because of the some political reason that there was a communist party in Kerala and Congress was not happy with its functioning, and later on the president rule was imposed. And later on there was a Sarkaria commission was also formed, which have given certain things like that. They have certain observations in the Sarkaria commission that governor role should be very no doubt that in Indian context the governor role is very, very important, because of the reason that I told you that in India, governor plays an important role in the realm that he is basically a link between the union government and the state government. But across the parties, whichever government they have come to power, so they have misused the position of the governor. So some suggestion is that till the time the governor is not having the security of the tenure, till the time the government is not having the security of the tenure, so the governor role will be that much only. As far as the speaker role is concerned, the Supreme Court have little bit step in that particular realm by saying that you have to take the decision within 3 months. And the same way, I think there should be something should be done by I think it should be done if the speaker or the parliament is making the change, and say that in the case of particularly resignation, so there should be some time limit that within this much time the resignation should be accepted or rejected. So you cannot delay it for a very, very long period of time. So there should be some guideline. There's a need of some guideline in the realm of the governor as well as the speaker. Otherwise, if the things keep on going like this, so maybe there's a time that, as you are saying, that the governor role, and of course it is now also in big question mark, but there will be a bigger question mark in future also. That is my observation on this thing.
Thank you so much, sir. The next question is by Ms. Varsha Kumar. She is asking if the governor has given orders, can political parties challenge it in court, as it happened during the formation of Maharashtra government in 2019?
Of course, because right now saying whatever decision, many times what happens, the governor will give too much of a time to form the government. So as it happened in the case of the Karnataka. So if you all remember in 2018, I think once the election, it was 17 or 18, once the election result was announced in Karnataka, so BJP was the single largest party, and thereafter there was a coalition happened between JDS and Congress. Governor gave first chance to the BJP, and governor gave, I think at that point of time, I think if I'm not wrong, I think 2 week or 3 week to prove the majority. So the matter went to the Supreme Court, and Supreme Court said that this is too much of a time, because there's a great chance that if you give more time, there's a great chance of horse trading. The Supreme Court, I think, reduced the time to 2 days, 2 or 3 days. So Supreme Court, what was given by the governor 14 days to prove the majority, so it was reduced, I think, to 2 or 3 days. So decision of the speaker is subject to challenge. So no doubt, because judicial review is there. So now every decision of the governor is subject to judicial challenge.
Thank you so much, sir. So the next question is by Mr. Jadumani Khamari. He is asking, a governor does not govern and a speaker does not speak. Why is it said so?
So as I told you the reason why he is saying so, because of the events, the controversies which are there with the speaker. So I remember very, very fondly that in UP, Kalyan Singh was the chief minister. Kalyan Singh was the chief minister. And later on, the governor gave vote to the Jagdambika Pal. So he was the chief minister for a single day. Next day, the writ petition was filed in the High Court, and the matter went to the Supreme Court. And then the Supreme Court asked the governor to let Kalyan Singh prove the majority, and then Kalyan Singh proved the majority and he replaces the Jagdambika Pal. So the question is that as till the time the constitution will not be very, very clear about the exact role of the governor, that what he can do, what he should not do. If the role is not very, very clear, then there will always be a problem. Same thing with the speaker, because generally what happens, whatever is happening in the assembly, the proceeding of the house is not subject to judicial review. Article 122 is for the parliament, and I'm not remembering the article which is there for the state assembly, but the same thing is there for the state assembly also, that whatever the proceeding of the house is not subject to judicial challenge. So there should be some clarity in the role of the two of the important functionaries. Why I'm saying important functionaries, because governor is a very, very important functionary, and as well as the speaker is a very, very important functionary. But the thing is that if you are in opposition, then you will put forward these questions that you are minimizing the role of the governor, you are minimizing the role of the speaker. But the same party, when they come to the power, so they will do the same thing. So technically, in my opinion, no party wants to reform this position of the governor or the speaker, because they knew very well that in a democracy, the government will keep on changing. So if something is taking advantage today and I am at receiving it, maybe in future I will be there in the government, and the people who are taking the advantage, maybe they will be at the receiving end. So something is there, unanimity in I think across the parties, that's why they don't want to touch the role of the governor and the role of the speaker. So maybe in future, I think something from the Supreme Court under Article 142, some guidelines related to that can only be a savior.
Thank you, sir. Thank you so much. One of our questions from the YouTube viewers, he has asked a question. He's saying that, is there any way out if the speaker delays in taking decision whether defection is there or not?
That's what I'm saying. The only thing is that you can go to the Supreme Court. As I told you in the case of the Manipur. So Manipur Assembly is a very, very interesting case. The person who defected from the Congress, he was made a minister in the case of the BJP. So he jumped to the party and he was made the minister. Now Congress is filing this anti-defection petition before the speaker. The speaker is not taking any decision. Now the matter went to the Supreme Court, and the Supreme Court is saying to the speaker, kindly take the decision within 90 days. Now what happened? Still the speaker is not able to take any decision within 90 days. Then finally what the Supreme Court have done, the Supreme Court have asked the minister, the MLA who have come from Congress to the BJP, the Supreme Court have asked him to resign. So that minister have to resign in that particular case. So I think in future, maybe the Supreme Court is going to play a dominant role in this particular scenario.
Thank you, sir. So with your permission, can I take 2-3 more questions?
Yes, ma'am.
Okay, sir. So the next question is by one of our participants. He's asking, what is the status in either House or Parliament or the state legislature of a member who is expelled from the party which set him or her up as a candidate for election?
Okay, so the constitution is very, very clear that anti-defection law, because the anti-defection law is nothing saying about the expelled member. So if you expelled a member, I'm saying expelled a member. So if you expelled a member, then technically till the time he is there, he will belong to the ruling party. So take the example of this Kapil Mishra in state of Delhi Assembly. So even if you expelled, so on expulsion, the anti-defection law is not applicable. So that is another gray area in our whole anti-defection law. So when party expelled a member, legislative assembly, then anti-defection law is not applicable. So he cannot join any other party. So he cannot move to any other party. So he will remain with the party itself.
Thank you so much, sir. Sir, the last question, I'll take up the last question. A participant is asking, do you think anti-defection law succeeded in meeting its intended objectives?
Okay, so that's what I'm saying, that if you go by the data, so if you go by the data, what was there before 1985 and what is there after 1985, to a certain extent, of course, anti-defection law is able to play a crucial role in minimizing this whole thing. Apart from that, there's one more thing, which is there is a whip. So whip is also an important tool in the political party hands to maintain the party discipline. So if what happens if there's a voting happening on any important issue in the parliament, the party will issue a whip. Whip is basically an order coming from the party, and the party will direct all the MPs or the MLAs to vote in a particular manner. And if you don't follow the whip, then it can be a ground of your disqualification. So some people say that whip is anti-democratic. Why? Because even the MP cannot act on his own. But why whip is essential? Because of the reason that it is essential for maintaining the party discipline. Because as I told you, you won the election because you belong to a party. So in a way, you should follow the party direction. So anti-defection law to a certain extent have able to fulfill its objective, especially after this 1/3 part was removed in 2000. So because 1/3 defection was very, very easy to manage, especially in the state assembly. So you will not find anti-defection law playing very dominant role in the national politics, in the parliament, because generally it is not a big thing there. So anti-defection law will be very much in news in state elections, state parties, because there will be many state parties having certain MLAs and MPs. So it is very easy to defect them. So finally it was realized and we have removed this 1/3 defection. So still this 2/3 is there, and it is very, very difficult to manage this 2/3. But what is happening right now, that is you are taking this resignation. So of course the constitution say that MP and MLA can resign at any point of time. So now whether through some deal or some anything, if the people are resigning, then anti-defection law is not able to play its role. So maybe this is the new way in which the political parties are exploiting the loophole in the anti-defection law. But still, I will say that anti-defection law have played a good role in making this Ayaram Gayaram little bit difficult. Because do remember, the term political party, the term political party in the Indian Constitution comes into picture only in 1985. So without political party, the state cannot function, the parliament cannot function. But the term political party was not there in the Indian Constitution till 1985. The political party, the term itself came into existence in the Constitution through anti-defection law. So it is mentioned in anti-defection law right now. That is all what I want to say.
Thank you so much, sir, for answering the questions of our curious students and participants in such a wonderful manner. Thank you so much, sir. And once again, I extend a sincere gratitude on behalf of KLE Society's.
Okay, ma'am, I am getting one more question. I think it is sent to privately. States are passing law, not implementing the law passed by the center. Okay, so sir is asking that certain states, for example, Punjab have passed the law saying that they will not implement this farm bills, farm acts which are passed by the parliament. So as we know that agriculture is a state subject matter, but agriculture marketing, that is in the concurrent list. So it is more of a politics in my opinion. So certain states have passed it, but what will happen? The governor is not going to sign it. So it will not become a law at any point of time. No governor will sign it. And the only option available with the respective state government is that they can go and file the petition in the Supreme Court, which they have already filed. Just like when CA was passed, so many state assembly have passed resolution against the CA, but it is not going to make any difference regarding the constitutionality of any law. At the end of the day, it's the Supreme Court which will decide whether the law is constitutional, whether this Farm Act is within the concurrent list or it is overlapping with the agriculture matter in the state list. That is going to be decided by the Supreme Court of India.
Thank you so much, sir. Thank you so much for answering the question, and I extend a sincere gratitude to you for coming and delivering such a wonderful lecture. And once again, on behalf of KLE Society's KLE College of Law, Navi Mumbai, thank you so much, sir, for coming and giving us your views on such an important topic. Thank you so much, sir.
Thanks a lot, ma'am. And thank you for inviting me. It was pleasure here listening all the questions also, because it always good to see the questions coming after the lecture. So this motivates the people to work more hard. So thanks a lot.
Thank you, sir. So now I request our respected principals, Professor Dinkar Gitte, sir, to kindly give the closing address. Sir, over to you. I think there is some network issue. Sir will be joining soon.
Okay, okay, no.
Oh, sorry. Yeah. Yeah. Good evening, one and all. Yeah. Good evening to all. Am I audible now?
Yes, sir, you are audible.
Am I audible?
Yes, sir. Yes, sir.
Okay. Good evening to all. On behalf, I would like to thank Professor Ashutosh for gracing today's session and sharing his views. I mean, it was a fantastic lecture and a very informative session and a very good questions, and he has answered them very patiently. That shows a command on the subject by an professor. I once again I would like to thank on behalf of KLE Society for giving his valuable and precious time for this webinar series. So, and he happens to be a very good friend of mine. To bring it on record, let me tell you, sir is a very good. He runs almost 20 to 25 kilometers, and he inspires all of us. And I could remember that he was a captain of our cricket team, and I mean, we had an occasion of playing against the National Law School LLB team, which we won for the first time in the history of NLS, that PG winning against undergraduates. So, with you. Now, having said that, we are witnessing the end of this 9th webinar series, which started from October 17, 2020. We witnessed the lectures of some wonderful speakers like Dr. Kumtia Debarma, Professor Swati Sharma, Romaisa Bhatt, Ashish Kaushik, Nanda Devi Deka, Naveen Dahiya, and of course, our guest speaker for today. I'm also obliged to the KLE management, especially Dr. Prabhakar Kureji, Chairman KLE Society, Mr. Mahantesh Kavadgimat, Sir Governing Body Chairman, KLE College of Law, MLC and Chief Whip, Government of Karnataka, Dr. Mallikarjunaya, Principal KLE College of Law, Bangalore, and Director KLE Law Academy, Bangalore, for the continuous inspiration and guidance throughout our webinar series. And sir, under your leadership, we surely will reach new levels in the academic field. Overwhelmed by the success of National Webinar Series, we plan to have more such webinars and panel discussions in future, and request our revered speakers to come and grace the event once again. A big thanks to my teachers, especially Dr. Amrita Singh and Professor Pooja Bezargi, who have been handling and coordinating the webinar series. This is the 9th one. So almost they have done a wonderful job, and despite of the fact today is Sunday, my teachers never complain with respect to the holidays or Sundays or whatever it is. They keep on working day and night. And I'm very happy that I have got, this institution has got a very good teachers in the form of Dr. Amrita Singh and Pooja Bezargi. They have done a wonderful job, and all the student volunteers who are working very nice. The webinar team, especially Atul for making such great posters. I'm also grateful to the participants who join us on Zoom and as well as on YouTube from all over the India, and even from abroad in some of the webinar series, without whom the webinar could not have been such a grand success. Thank you all once again. Without wasting much of a time, now I think I would like to hand over this session to Dr. Amrita Singh. Over to you, ma'am.
Thank you so much, sir, for those kind words. And you are always an inspiration behind all of us, motivating us for achieving more and more. Thank you so much, sir, for those kind words. And once again, thank you so much, Professor Ashutosh, sir, for coming, joining, and giving us a wonderful lecture. Thanks a lot, sir.
Thanks a lot, ma'am. Thanks a lot, Dinkar. Thanks a lot, participants.
Thank you, sir. Thank you so much.
Okay.
With this, we end the meeting.